SJC-12518, Commonwealth v. Francis T. Brennan.
Mr. Kutzall. Still morning.
Thank you. May it please the court. My name is 88 David Cutchall. I represent the Commonwealth in this case. I'm here today to ask the court to reverse the dismissal of a complaint that is supported by probable cause to believe that the defendant committed 2 counts of criminal harassment. This defendant, Francis Brennan, is accused of going underneath 2 people's vehicles, a husband and wife named James and Jillian, whom the defendant had never met before and were complete strangers to him. The defendant attached GPS tracking devices to the undersides of both those 2 vehicles, and the defendant tracked those 2 vehicles' locations over the course of 10 days at least 17 times. When he was discovered by the police and confronted by the police department and the Coast Guard investigators, the defendant told them that he was, quote, guarding the hen house. He was making sure that his backyard was clear. He accused the husband, James, of having an affair, and he told the police and Coast Guard that James's wife might want to start checking her phone.
So you're saying that the behavior was creepy, but it wasn't acts of harassment, or it was acts of harassment?
I'm absolutely saying that it was conduct that constitutes criminal harassment, which is defined under Chapter 265, Section 43A, as willfully and maliciously engaging in a pattern of conduct or series of acts over a period of time directed at a specific person, which seriously alarms that person and would cause a reasonable person to suffer substantial emotional distress.
How many events were there?
Your Honor, I submit that against each of those victims, James and Jillian, there was 1 event for the planting of the tracking device on 1 car, 1 event for the planting of the tracking device on the other car, 17 events for 17 separate incidences that the police were able to determine the defendant had tracked the locations, had actually researched the longitude and latitude coordinates.
Each time he tried to track it?
I'm sorry, Your Honor?
Each time he tried to track it, that was a separate event?
Every time that he tried to track it, it was a separate event, Your Honor. Commonwealth versus Valentin, which addresses the stalking statute, a very similar statute, addresses what constitutes a separate incident as part of a pattern of conduct. And the court held that the acts may occur on the same day, in very close proximity and time to one another. They need only be separate, distinct, and separated by some interval of time.
Suppose it was continuous tracking.
The tracking of the devices was literally possible, but the police were able to separate, according to time, date, and place, 17 individual instances when the defendant had researched those locations and what those locations were.
So there was continuous tracking, it's just that the defendant looked at them on specific dates, and the argument is that the looking at them causes an act, is that right?
That's right, Your Honor.
Does it matter that the targets did not know?
That's precisely the crux of the issue in this case. There is no requirement under the statute or under the court's decisional interpretation of the criminal harassment statute that requires that a victim of harassment be subjectively aware of every act that makes up the pattern of acts. Commonwealth versus Johnson and Commonwealth versus Walters address the impact that the acts has on a person, and it holds that the impact, the serious alarm, need not be tied to every individual act that a person commits that comprises an overall pattern of conduct. The serious alarm is tied to the pattern of conduct itself.
Now, how is this different than the case in which the court held that driving by a house 3 times was 1 act?
This is different in the sense that the driving by the house 3 times, which was Smith v. Masterles, which was interpreting the harassment prevention order that had been issued rather than the criminal harassment statute, although they're very similar, found that the person in that case who had driven by the restraining order defendant's house 3 times, it was done in quick succession within a matter of seconds, and it essentially comprised 1 act. These instances of the defendant first going underneath 2 vehicles and installing the tracking devices, and then actually tracking those locations over the course of days, 6 individual days there was tracking over the course of 10 days overall, and they were separated into 17 different incidents. Now, at best, if the defendant wanted to avail himself of Smith v. Masterless and say that some of those were really one incident of tracking, I submit that the several instances of tracking that occurred within a couple of minutes of each other, all on that one day where he was following James and Jillian through Rhode Island, those might be combined into one under Smith v. Masterless, but certainly they're well beyond the three separate incidents.
Where's the intent to cause fear or intimidation?
The intent element of this offense is the fifth element, willful and malicious conduct. That is defined by the Court of Appeals in Commonwealth v. O'Neill as intentional conduct without justification where any reasonable person would have foreseen the actual harm that resulted. And any prudent person in the defendant's shoes that is going up to a stranger's car, installing a GPS tracking device, and following those people around, and then making unfounded allegations about infidelity in those people's marriage.
What if they don't do that? What if they just track them and then take the device off or let the battery expire and they never find out?
I'm not going to suggest, Your Honor, that there aren't situations in which a person could utilize a GPS device on a civilian and not run afoul of the criminal harassment statute. I'm saying that in this case there was probable cause, the lowest standard that we have to find that the defendant did commit acts of criminal harassment where he was a stranger to the victims of this tracking, and that he took the extra step of making those statements that he was guarding his hen house and that his wife might want to start checking his phone. There was an amicus brief submitted in this case by the Private Investigators Association that indicated that it is probably not socially utile to allow civilians to be conducting GPS tracking in this manner.
That raises two questions. There's also a statute that says that you cannot perform private investigator function if you're a civilian and you haven't been trained and licensed. So arguably, and I think is that a criminal statute?
It is.
Okay, so could he have been charged with that crime, do you think?
I don't know enough about the law of impersonating a private investigator to answer that question fully.
And then my second question is, why is it okay for a private investigator to do that?
The reason that I think a private investigator wouldn't necessarily run afoul of the criminal harassment statute by using a GPS tracking device is twofold. One, because the element of willfulness and maliciousness has an element that it is without justification, and a private investigator may well have a justification for utilizing a GPS tracking device.
Getting paid would be the justification.
Potentially.
Potentially.
The other is that a private investigator would not necessarily cause a reasonable person to suffer substantial emotional distress whenever they are utilizing one.
Suppose this defendant had hired a private investigator to put the device on for him and to send him a report every so often.
It's entirely possible that the defendant hiring a private investigator to install a GPS tracking device might not have caused the defendant to run afoul of this statute. It might change the analysis of whether the victims would have been seriously alarmed, and even if so, if a reasonable person under the circumstances would have been seriously alarmed by the defendant's conduct. But that's not what he did. He did it himself, and then he offered an explanation to the police as to why he was doing it that had the effect of causing serious alarm and would cause a reasonable person in James and Jillian's shoes to be very fearful of what the defendant's intentions are. I mean, this is ominous language that he's using when he says, "I'm guarding the hen house." And he's discovered only by the serendipity of James taking his vehicle into the mechanic and finding out that there's a GPS tracking device on it, not knowing how far this defendant would have gone had he not been confronted and stopped by the police.
The case law that you point out is that being alarmed can happen after the fact, right? And what's the support for that authority?
Johnson and Walters are two cases decided by this court that indicate that the serious alarm element is tied to the defendant's overall pattern of conduct and need not be produced by each individual act that makes up the pattern of conduct.
So we've decoupled act from alarm as far as separate acts. So it has to be separate acts.
Yes.
That alarm.
Johnson employs a very useful logical exposition on what word modifies what word in the criminal harassment statute and finds that serious alarm is modifying the pattern of conduct and not the individual act.
Maybe if the wife had done this and it seriously alarmed the husband, would she be guilty of this crime?
A fact finder or a neutral magistrate under those circumstances would have to evaluate whether it was reasonable that a reasonable person in the victim's shoes in that type of situation would have suffered substantial emotional distress, which is defined in Commonwealth versus O'Neill as that markedly beyond which is experienced as part of ordinary living,
I mean, you have one situation in which it's creepy that some stranger is knowing what you're doing 24/7, but you may not want your spouse to know what you're doing 24/7. What if it's a company with regard to workers' comp, trying to demonstrate that the person's not actually disabled?
I think a company employing this technology to track somebody, if the victim on that case understands why and understands that there is a lawful, reasonable purpose that's being employed by an agency that is accountable, or in the case of private investigators, is licensed and is subject to having that person's license revoked, then that is less likely to evoke the serious alarm, and it is less likely that that would cause a reasonable person to suffer substantial emotional distress, as opposed to this case where this defendant is a stranger and has no private investigator certification, and there's no apparent reason or motivation that these two victims can understand as to why he has become involved in their lives at all.
Because he thinks the husband's having an affair with his wife.
Your Honor, the interesting thing about that is that the defendant wouldn't articulate when he spoke to the police whom he believed James was having an affair with, and defendant's
Guarding
brief
his hen
points out.
house.
Excuse me?
He was guarding his hen house, wasn't he?
He was guarding his hen house, but he didn't say that he believed that James was having an affair with his wife, and the defendant's own brief points out that he was not married at the time, which only adds
He wasn't
to
married at the time?
That's my understanding. So that only adds to the mysticism of this entire enterprise that he is engaged in and why it would cause them serious alarm.
So are you focused on the without justification part, or are you focused on the serious alarm part? I mean, I'm trying to see what distinguishes this from any private investigator doing surveillance of individuals over the course of time, which is sort of what private investigators do, which is probably why they were worried enough to put together a brief. So what separates out the usual work of a private investigator from this type of surveillance?
The amicus brief that was submitted goes to great lengths to point out the certification process that's required of private investigators and the sort of accountability that they have in our society as people who are entrusted to use this type of technology for means that are lawful, as opposed to an individual citizen using them for whatever that person wants to do. And this is conduct that, if the police were doing it, would require a warrant under Commonwealth versus Connolly. And
But I mean, the concern I have is that, okay, so somebody who has no money does it himself, and somebody who has a lot of money hires a PI, and we have a different outcome? Just because somebody can put in $5,000 and say, I'm going to hire somebody to do it, as opposed to I'll do it myself?
this is not income or financial means dependent, it's conduct dependent. And
It would be the same conduct if a PI did it.
Sorry.
whether a rich person does the act himself or whether a poor person does the act himself, he faces the same criminal liability as
How about if a rich person hires a PI to do it?
a rich person may well hire a private investigator to do it. And I'm not saying that a private investigator hired by a rich person might never run afoul of the criminal harassment statute. It depends on the conduct that a person employs to achieve their purpose and whether their conduct causes serious alarm and whether any reasonable person in the defendant's shoes would have foreseen the harm that resulted. And any reasonable person in the, yes, Your Honor.
So you're saying that the private investigator puts the two tracking devices on the cars without telling the people whose cars that he's doing this to, plus 17 times he checks it. That's okay.
I'm not expressing an opinion one way or another as to
We need
whether,
to know whether that's okay.
excuse me?
We need to know whether that's okay. Is that okay?
The only thing that Your Honor has to decide is whether there's probable cause to charge this defendant under this
Yes,
set
but
of
we
facts.
have to think beyond this case, don't we?
Yes, you do. Yes, you do. But there's nothing about what the defendant has done that requires you to make a determination about whether or not a private investigator would be criminally liable for doing what private investigators do. And the amicus brief submitted by the private investigators isn't taking a position one way or another on whether the defendant could be criminally liable. In this case, they are emphasizing that this is technology that is appropriately used in the hands of licensed investigators and not in the hands of civilians who are unaccountable to the public.
Is it not a civil invasion of privacy to do this in violation of or rules with regard to privacy?
I'm
Do
a
we
humble
permit
public
private
servant
persons
without,
to do this? Sorry?
I'm a humble public servant without sufficient expertise in the law
Well,
of
I'm just
civil
wondering whether or
litigation
not the
to-
key element is the GPS as opposed to just surveillance. I mean, would we be in the same situation if we had somebody outside their home who was doing physical surveillance of them over the course of time? Or is it or does the GPS change something?
I think that the physical surveillance of a person at a location where the victims are would very much implicate the criminal harassment statute just as well as using a GPS tracking device, yes.
That's what PIs do all the time.
I'm not suggesting that that conduct would necessarily run afoul of the criminal harassment statute. I'm saying that there is probable cause to get past a motion to dismiss on this case for 2 counts of criminal harassment.
So
And
if this person hid in the bushes and watched the husband and wife through binoculars for 14 days, would that be criminal harassment?
Yes, I submit that it would.
Okay, thank you.
Thank you, Your Honor.
Ms. Bonanno?
Good morning. May it please the court, Sabrina Bonanno. I'm joined by Attorney Richard Sweeney. Together we represent Francis Brennan in this matter. I would suggest that in this case, we have novel issues as it relates to the criminal harassment statute because we have the placement of a GPS device, and we also have 2 parties, or I should say 3 parties, who have absolutely no interaction or communication. The complainants, Jillian Hessian and James Daly, have had no contact whatsoever with Francis Brennan. They haven't had contact during the pendency of this case. They haven't had contact prior to this case. The only times Ms. Hessian and Mr. Daly knew who Mr. Brennan was when the police informed them of that nature. And I suggest that the essence of the criminal harassment statute is harassment. The person has to know they are being harassed.
But haven't we held that it's a cumulative effect of the acts that causes the alarm in the person?
Correct. It can be the cumulative effect, but under Commonwealth versus McDonald, that's a case where the individual is driving around this neighborhood, taking photographs of dogs. They said that the reason it wasn't harassment in that case is because there was never an intention for the for the complainant to know the defendant's attention was focused on her.
It seems to me that the complainant or alleged victim or the plaintiff in a civil matter, it seems like they have to know of at least 3 times. Maybe they don't have to know the entire pattern based on our previous cases, but I'm looking at the elements from Commonwealth versus McDonald. And one of the elements is the conduct of speech, a series of acts were such a nature that they seriously alarmed the victim. You can't be seriously alarmed about something you don't know about.
Correct.
So you have to at least know. Maybe you don't have to know every time, but you have to know about at least 3, right?
Correct. You have to, your intention, Mr. Brennan's intention had to be known to the victims. And I'd argue that because the GPS device was surreptitiously placed on the vehicles. On Ms. Hessian's vehicle, it was in the wheel well. Under Mr. Daly's vehicle, it was in the spare tire. He didn't place it on the windshield. He hid those devices because he did not want them to know that they were being tracked.
So I'm sorry.
Oh, go ahead. Your question will be better than mine.
I don't think so. I guess we'll see. So if your client took a ladder and snuck up to the 2nd floor window of this couple and watched them sleep every night for 3 weeks, and then on the last night, as he's leaving, he's arrested and confesses to this, and the police say, oh, by the way, this guy's been watching you sleep for the last 3 weeks. That's not criminal harassment?
I would suggest that that's a different offense. One,
That's why I
think it would
asked
be
it.
trespass because you're
No,
going onto
but
these
let's
people's
focus on my
property.
question about the criminal harassment. Would that be criminal harassment?
I would suggest that it's not criminal harassment, mainly because of the other elements in the statute. There has to be an intent on his behalf for them to know he is doing this. That is the essence of harassment, that you know I am doing something to you that is causing you serious alarm, that I'm doing something that makes you aware of my presence. Like in the Commonwealth versus Patton case, the individual, the defendant in that case, went to this woman's place of work over 20 times. He paced, he glared at her, he made his presence known. He would ask for her. If she wasn't there, he would leave. He showed up at her gym. She knew he was there. But if he had just gone to this restaurant and sat down and she never knew he existed, where's the criminal harassment?
I guess your argument might be as simple as you can't harass somebody who doesn't know that you're doing something.
Correct. Unless you know, where is the harassment?
Except that at some point you do know and you say, holy whatever, this is a really creepy guy who's been, for whatever reason, surveilling my activity, and I'm really frightened about that.
But McDonald suggests that it has to be Mr. Brennan's intent for them to know. I understand and I agree, they found the devices, but his intent was never for them to find them, which is why the devices were hidden. He didn't intend for them to find out, which is why he didn't put the device on a windshield or put it in a place where they would readily find it.
Well, why would you ever put a GPS device on somebody and then expose it to their view?
Well, and that's my point, because he didn't want them to know. He
But-
didn't, I apologize.
Does the case change if they find the GPS devices, unbeknownst to him, and they just let it go, and then 17 times he checks it after that? Does that make any difference?
It would make a difference depending on what acts he's being charged with. So in this case, I think what the Commonwealth is trying to argue is that you have the separate acts of placing the GPS device and then the separate 17 times it was located. My argument would be that those 17 times are not separate acts. The act is the placement of the GPS. The Google mapping of those locations is the purpose of the device. You know when you find the device that its purpose is to send out a signal of where you're located. So whether you map it once, whether you map it 17 times, or whether it's a continuous 24/7 hours a day, it's a continuing act from the initial placement of the device.
Well, you're arguing it's not even an act because it's surreptitious.
Well, correct. Assuming arguendo that you find the placement of the device is an act, the 17 times it's mapped are not separate acts.
Now, counsel, assuming we agree with you, this is bad behavior. So what would be the appropriate charge?
As the laws are written today, what Mr. Brennan did is not criminal. I think the appropriate remedy is for the legislature to go back and to examine whether or not placing an electronic monitoring device under someone's vehicle should be a criminal offense. There are multiple dozens of states that have specific laws prescribing that kind of behavior.
Like upskirting.
I'm sorry?
It's like the upskirting case you're saying.
Correct, like Robertson. This court found that while the intent of the legislature may have been to criminalize that conduct, the statute wasn't that in effect.
Are they trespass type crimes?
I would argue no, because the trespass statute specifically addresses.
No, not in this state, but the states that have addressed it, have they addressed it similarly to trespass?
I only read the statutes, and what the statutes basically say is
Just
any
don't do this.
person that places this device shall be punished. Some states have differences where if it's consented to versus not consented to, but Massachusetts does not have a specific statute criminalizing that. If any layperson was to go online and say, is GPS tracking criminal in Massachusetts, the answer would be no, because no criminal offense would come back to that. And I suggest that the Commonwealth recognizes that this behavior was bad and that it should be punished, but it doesn't make it criminal.
Going back to the intent issue, I think ADA Cutshall said that wanton and reckless behavior takes the place of intent in a way. You don't agree with that? So he did something that obviously had someone known, and they did find out, but he behaved in a way that would obviously make anyone concerned about the behavior.
Well, I would suggest that under the maliciousness standard set out in McDonald, that it says it has to be without legal justification or excuse. And in this case, what Mr. Brennan conveyed to the police was he was checking his hen house. He was clearing his backyard. He was investigating whether or not Mr. Daly was having an affair. And as my brother alluded to, Mr. Brennan is not married. He did have a girlfriend at the time, though. So he was investigating whether or not.
Want us to say, as a matter of law, that's okay? That that's a good excuse?
But
We're gonna have the guard in the hen house exception?
well, you're allowed to do private investigations. He is allowed to investigate something of this nature, and that's what he was
But
doing.
he's not allowed to do an act that a private investigator is doing, isn't that right, under the private investigation statutes?
Well, the private investigation statutes, I think, apply when you're holding yourself out as a private investigator. Mr. Brennan is not holding him out as an investigator to investigate on other people's behalves. He is investigating on behalf of himself. And as Chief Justice Gantz stated, the difference between whether or not this is a crime shouldn't depend on whether or not someone can afford to hire a private investigator. If Mr. Brennan had hired a private investigator, would we even be here today? But because he couldn't afford it, that somehow makes it criminal harassment. The private investigator would have obtained the exact same information that Mr. Brennan did. They would have placed the device, they would have conducted the searches, they would have provided all that information to Mr. Brennan. There is no difference between a private citizen conducting an investigation on their own behalf, as long as they're not running afoul of any other laws.
Private investigators answerable to the Commonwealth through their licensing authority, correct? That's why private investigators can do some things that other people can't, because they're licensed by the state police.
Correct, but they're acting and investigating on other people's behalves. Mr. Brennan was investigating on his own
But
behalf.
it's if the private investigator exceeds the bounds of propriety, they lose their license, right? A regular citizen doesn't.
Right. I'm not too familiar with whether or not they would lose their license, but if they go afoul of that, they would lose their license. But in this case, if you're investigating on your own behalf and there isn't a specific law criminalizing what you're doing, it's not a crime.
Well, that's the issue.
Correct.
I guess we'll
That is
find
the
out.
issue.
So let's go through the elements a little bit.
Yes.
The elements of directed at a specific person, of course, were met. This was directed at,
And I would argue that there isn't enough evidence to show who it was directed at.
well,
Because you have,
really?
Whose car was it?
yes.
He put a GPS on the car of the husband and the wife. It's not clear it's directed at them?
Well, it's not, there's no indication that he knew who drove which car. The location searched in the 17 locations, it doesn't say whether it was Ms. Hessian's car that was searched, whether it was Mr. Daly's, whose car was mapped one time, whose car was mapped multiple times.
Well,
It's
that's
unclear.
Maybe why he did both is because he wasn't sure which car he drove. But, okay, let's assume you're not going to persuade us on the directed at a specific person element. Which seriously alarms that person. Is there any reason to think that we should not find that there's at least probable cause to believe, or I guess it's conviction, right?
I concede they were seriously alarmed.
Okay, and then it would cause a reasonable person to suffer emotional distress.
I think that is an issue more apt for a jury to determine as well.
Okay, so, but in terms of getting
Past
over
the
the hump.
probable cause stage,
Okay,
yes.
so then the issue comes in whether it's willfully and maliciously engages in a knowing pattern of conduct. So the issue is willful or malicious.
Willful or malicious, and whether there are 3 or more acts.
Okay, so, right, so I
Or is it
understand you
also
got
knowing?
those issues. So, I'm just, is the issue justification? I mean, if you have a boyfriend who is upset that his ex-girlfriend is now arguably seeing somebody else and decides he's going to do this to her so that he can see whether, a jealous boyfriend, ex-boyfriend can now see what his girlfriend is currently doing, that's okay? That's not a crime?
Under the criminal harassment statute, it's not. Because if you're not intending for your girlfriend to know, it's not a crime. Now, if he used a GPS tracking device, finds out where she is, and then shows up at that place, I would suggest that would count as an act of harassment. But if you're just tracking the movements, that is not harassment,
Well, if you
because
say-
they don't know what you're doing.
So successfully surveilling somebody, a successful discrete surveillance is not a crime, but an indiscreet surveillance is.
I don't
But
think
the street
either.
surveillance mean you're not caught, that you're doing it covertly and they don't know they're watching you.
Or
but
if the boyfriend was just following her down the street on a public way, which he has access to, he has every right to do that, which is the same. The GPS device does go into some more privacy issues than just following someone down the street, but it's the same premise. You have every right to follow someone down the street until they know you were there.
I don't think any other defense attorney who stood up here hasn't argued that on GPS versus following people down the street. The GPS is a little bit more than following someone
Correct.
down the street, right?
It
As
is
far as
more than that.
What the glimpse it gives of one's life and
But
privacy.
and I'm trying to use it in the sense of, but what does the person know? If you're being tracked by a GPS or you're being followed down the street, if you don't know the person is there, that cannot be harassment, because the harassment statute requires there to be some sort of interaction. When we look at Patton, when we look at McDonald, when we look at all these cases, the reason harassment is found is because there's an interaction between the complainants and the defendant. Here, you don't have any interaction whatsoever, and that is the basis of harassment.
Can you just tell me what element that goes to? I mean, I don't understand how that goes to willfully and maliciously engage in a knowing pattern.
It goes on,
The interaction that you're talking about, what does that go to? What element does that go to?
I would suggest it goes towards the willful and malicious. When you're reading McDonald, McDonald basically says there was no evidence that he ever intended to target the complainants or that he ever intended them to be aware of his attention.
Somehow willful and malicious requires intent to have them know?
Correct, because maliciousness in and of itself, if you want your act to cause them harm, to, in a sense, make them aware that you're there, that is maliciousness. You need an intent to cause that, as opposed to willful, which is just, in this case, placing the device under the vehicle.
You're basically saying you must intend to cause fear.
Correct.
It's not sufficient that you intend to do an act which, when later revealed, causes fear.
Because maliciousness, willfulness and maliciousness require the conduct and the harmful consequences. He didn't intend the harmful consequences. Anyone who places a GPS device under someone's vehicle isn't going to anticipate that they're going to find the device. They're going to take it to the police. The police will then, in this case, give it to the Coast Guard, who then gets an administrative subpoena that they send to Brick House Security, where they get the defendant's name, that then 2 special agents and a detective will show up at your house, seize your laptop and your iPhone, get a search warrant, search those items, then compare all the locations that were Google mapped in your computer to the locations provided by Brick House Security. A reasonable person would never expect that kind of thing to happen. And I think that
Reasonable
goes...
person might not do it in the first place.
I apologize.
A reasonable person might not do it in the first place.
Well, I think if you're investigating and you were just trying to determine whether or not an affair's happening,
It's just
that's why
creepy.
you tracked it.
I wouldn't follow that road.
Okay. Thank
If there are
you.
no further questions, thank you.